Welcome everyone to this afternoon sessions of the European Animal Rights Law Conference. Now, before I kick off this session, maybe two disclaimers. First, as you probably recognize by now, I'm not a native English speaker, so my apologies for any weird pronunciation or grammatical errors and so on. Secondly, I will not be able to attend to the Q&A. So please write any questions you have, write them down so you can email them later. Now, so at least that's the case for me. My food baby is still sinking in, so I will start with a funny anecdote regarding this slide. On this slide, many of you may already know, you see 11 countries who have a kind of constitutional obligation towards animals. Now, a couple of months ago, I was actually invited in the Belgian Senate to give advice on inserting an animal welfare state objective in the Belgian Constitution. And there I exactly showed the very same slide, and one of the members of the Belgian Senate pointed out that the Netherlands currently do not have a constitutional provision, so that the flag on the slide is probably a mistake. So I answered him that he is indeed right. So the Netherlands currently do not have such a provision. Yet I mentioned that he probably mistakes the flag from the Netherlands with the one of the Luxembourg. And I can assure you that it was a very awkward moment. Now, I will also introduce myself really briefly. So as Raphael already mentioned, I'm teaching the specialized course to Master Law students, Animal and Law. I also co-teach the course Agrarian Law to Master students of the Faculty of Bioscience Engineering. Now, my main three research areas are animals and constitutions, animals and sustainable development, and compassionate conservation. Of course, I have many more, but these are my three core topics. Finally, I'm also co-founder of the Harrison Collective, which is a Belgian NGO that advocates for farm animals using specifically law instruments. So the structure of my presentation. First part, animal rights constitutionalism. And we had this discussion already going on with Raphael mentioning the tin and tick rights, also the framework from Saskia Stuckey, the simple and fundamental animal rights. So for now, I will just use the umbrella term animal rights, and I will clarify later on what is lodged under that. So my inspiration for this animal rights constitutionalism is based on these two books. And I think the same analogy applies for animal law. So we also have the constitutionalization of animal protection. And to stay with this comparison, on the left side you can see the book cover of David Boyd, who was a UN Special Rapporteur on Human Rights and the Environment from 2018 until 2021. And he made a list of constitutional environmental provisions, and he identified 147 provisions. Now, during my PhD, I did the same exercise for sustainable development provisions. And there, the result was 105 provisions. Now, a book you can almost always find on my desk is this one, because I think it's really important to not always want to reinvent the wheel, but also look to what is already there and what we can use from it. And I think here you have plenty of leeway, especially regarding this constitutionalization. So I mentioned the numbers of 105, 147, and maybe this map will look familiar as Sabine used it yesterday in her presentation. So we have already 2/3 of the countries, or 113 countries, that have some kind of national domestic legislation, an Animal Welfare Act, Anti-Cruelty Act, and so on. But that's not on a constitutional level. And here we come back at the start. I will not go in depth on all these countries, so I will elaborate on a few of them to show you differences in phrasing, in scope, and so on. To give an example, a constitutional provision can be written in the form of a ban, but can also be written in the form of an objective. An example where it's written as a ban is Brazil. Article 225, if I'm not mistaken, stipulates that practices which subject animals to cruelty are prohibited. And this provision allows to annul any regulation or law that violates this provision. In practice, we see that this provision is mainly used to fight against cultural traditions such as the Feast of the Ox, rodeo events, cockfighting, and so on. Similar, if you look to the content, however written as an objective, is the constitutional provision in Egypt. In 2014, Egypt adopted a new constitution where it also included a constitutional obligation on animal protection. And with both provisions, you see a shift from conservationism to ethocentrism. As Article 45 of the Egyptian constitution stipulates that the state must prevent that animals are subject to cruelty. And here we see that the provision is primarily dedicated to conservationism, but animals are protected as well. Should you be interested to read more about this Egyptian provision, I can refer to Kristen Still, who wrote a journal article on it, Constitutional Innovation in Animal Protection in Egypt. What is special if a provision is written as an objective is that it can have 4 legal effects. So first, it contains the rights for humans of conscientious objection. Second, for public authorities in particular, it contains the obligation to ensure the enforcement of law. Third, which is also very important, is judicial interpretation heuristic. And fourthly, and most importantly, is that it can be a basis for limiting other fundamental rights such as economic freedom, professional freedom, sexual freedom, and so on. Another example, which is probably most renowned one, is Germany. And also, for instance, Luxembourg and not the Netherlands have such a state objective. No, I will not go in depth on Germany right now because it will come back further in my presentation. Going to Switzerland, in my opinion, it's rather an odd one, and this for 2 reasons, both regarding the phrasing as well as the scope. The scope, it's actually lodged under the title Non-Human Gene Technology. And the wording, it's paraphrased as the dignity of living beings. So this phrase was added in 1992 by popular vote. And we see that since 2005, it actually evolved into a bedrock principle for Swiss animal welfare law. It is mentioned both in Article 1 and Article 3 of the Swiss Animal Welfare Act. Similar to human dignity, individuals must be respected and protected for their own sake. And Article 3 of the Swiss Animal Welfare Act identifies 3 case groups of such dignity violations, which is extreme interference in their abilities and appearance. Think of excessive breeding exercises. Secondly, instrumentalization. Think of some kind of animal experimentation. And thirdly is dehumanization. Think of practices in circuses and so on. You see that these case groups go far beyond the mere prevention of animals subject to harm, unnecessary suffering, and so on. Now, finally, Ecuador. So it can also be seen rather as an odd one. We already had the fabulous presentation of the judge of the Constitutional Court yesterday. Well, I put it into the list. I also retrieved it from a list of Johan Schaffner, where she also mentioned that this provision, although it's more of a rights of nature provision, it includes compassion for all living beings, including animals. Now, as we have seen, is that it specifically targets wild animals. So the Estrelita case, so this wild animal to not go in depth on domestic animals. But if you apply this reasoning, you can also add two other countries, which are Colombia and Costa Rica. There we see that the right to environment, the judges of the Supreme Court accepted that it can also contain obligation for animals, not only wild animals, but domestic animals as well. Now, so for this brief introduction, of course, time is limited, but should you be interested in the topic, here you can find some bibliographical references. On a side note, a useful tool to compare constitutions is constitute.org. Now, we have seen the differences, but they have one thing in common, is that they are authentic legal norms that have concrete effects in legal system. So I'm talking about these countries, about animal rights, constitutionalism, and it's not something from the past. It's actually something that is happening right now. We have South Korea that has, in the recent past, also been considering this. And right now we also have proposals in Belgium, as I alluded before, and in Finland. And those two countries are exactly the jumping off point for my next part of the presentation. So the litigation part, as we all know, the general theme of this year's conference is litigation, so I decided to also incorporate it in my presentation. We have seen already the presentation of the Constitutional Court of Ecuador, and I will build on this presentation as I will give insight on the Belgian Constitutional Court and its attitude towards animal welfare rights, as well as the German Constitutional Court and the emergence of the German animal welfare state objective. So, first of all, Germany. So, in my PhD research, I examined the German animal welfare state objective, which has been in place since 2002. And one of the lessons I learned that the underlying reason to have this animal welfare state objective is due to the peculiarities of Germany's constitutional system, which is based in particular on the premise of the unity of the German basic law, which is confirmed by the Bundesverfassungsgericht in the Mephisto case. So we have a hierarchy of law. And if there was a conflict between a right in the Tierschutzgesetz, so in the German Animal Welfare Act, and the right in the German Constitution, this right in the German Constitution would always prevail above animal welfare. And to solve this inequity, it was decided to elevate animal welfare to a constitutional value, so that in the future it was at least possible to have a fair balancing exercise between two constitutional rights. Now, if we then look to Belgium, so that's my home country, and as I mentioned before, we currently do not have a Belgian animal welfare state objective. Now, to give some insight in the judgment of our Belgian Constitutional Court, well, on the slide, if you would mind counting them, we have 17 judgments, but recently we have a new one in July, so actually we have 18 now. Now, 3 are from a pre-Lisbon period, which I mean they are from a period before Article 13 of the Treaty of the Functioning of the European Union, which contains a policy animal welfare integration provision, was adopted. The first judgment of the Belgian Constitutional Court afterwards was this one. And here you see this statement that the Belgian Constitutional Court made. And we see that this reasoning, where it stated that animal welfare is a legitimate aim in the public interest, especially referring to Article 13 TFU, is consistently and repeatedly applied in all the judgments afterwards, in a whole range of content, so mink farms, circuses, tail docking, and so on. However, there are 2 exceptions, but they have nothing to do with the content. It's the Flemish firework bans and the Walloon Animal Welfare Code, because it was due to technical reasons between the division of powers of the federal level and the sub-state level in Belgium. Now, to go to comparison, on the one hand, we have German with its German animal welfare state objective, so that the Constitutional Court had tools to work with. In Belgium, we currently do not have such a benchmark, but here we see a very progressive attitude of the Belgian Constitutional Court to use Article 13 TVU instead. However, this very progressive attitude should also be nuanced, as there is an important limitation. So for now, the court could reject claims from opponents of animal welfare. But on the other hand, it could not give input for cases who want more animal welfare. And so that's a very important limitation. So a state objective or a constitutional provision in Belgium would fortify the current judicial activism. And what's more, and that's the linking thing to the last part, is that this debate, which is currently going on in Belgium, also opened the debate to fundamental animal rights. So we had several options: an animal welfare state objective, an economic, social right for animal protection in our constitution, and also this fundamental animal rights debate. And to give some inside information, last month in July I was contacted both by the Green Party as well as the Left Party on this topic. So for now all I can say is to be continued, but we see that it sparks interest for fundamental animal rights as well. And here we come, of course, with the finish line. As also in Finland, it's very topical. Now we have this proposal of the fundamental rights for animals. Now, I will not go in depth here because who else can guide you better through this than Brigitta herself? All I can say for now as a conclusion is that if this proposal would succeed, that it would definitely give a whole new momentum and dimension to the real animal rights constitutionalism. Now, initially I had this Q&A plan, but as mentioned before, my Eurostore decided otherwise. But please, you can see my email over there. Write them down and send them to me so I can answer your questions after all. Thank you for your attention.